We live in a global and interconnected world, and so it's critical that we look at ways to sort of bulk up the legal frameworks for resilience. And to drive that conversation, we have curated a panel for you. This is going to be led by Jonathan Wood, the chair of the International Arbitration at RPC. And with him on the panel are Joke Aliyu, managing partner at Aluko and Oyebode, Ning Fei, managing partner at the Hugh law firm, Stephen N. Feldman, global chair of complex commercial litigation and partner at Latham Watkins, Martina Polasek, secretary general at ICSID, and Abby Cohen Smutley, the global co-head of international arbitration and partner at White & Case. Please come to the stage.
Your Excellencies, ladies and gentlemen, welcome and hello to this panel on legal frameworks for resilience. Before we start, I'd like to pose a question. We live in quite extraordinary times. One day in the future, might it be possible that a leader in a particular country, it may be any country, it may be any leader, issue an executive order abolishing the resolution of commercial disputes in the state courts? This may be done for cost-cutting measures. It may be politically motivated. But where would it leave us if we did not have the state courts? I leave you with that thought as we now delve into this particular panel. I'm joined by an experienced panel, and we will discuss this afternoon the issues arising out of legal resilience. Thank you. It's well recognized that the rule of law is a fundamental pillar for achieving fair and broad-based growth and prosperity. The use of alternative dispute resolution mechanisms and the enforcement of contracts is key, as referred to by Audley Shepherd this morning. With its vision for 2030, for a vibrant society and a thriving economy, the Kingdom of Saudi Arabia is a prime example of a country and a nation in transformation. Our panel will consider the legal frameworks required to achieve this on a sustainable basis. From the point of view of businesses and foreign investors, we will look at the role and importance of institutions for dispute resolution, the role of ICSID, and we will also look at the position from two practitioners from other countries, China and Nigeria, who are also countries in a state of dynamic transition. So let me first start off with Steve Feldman. Steve, you've advised clients all over the world on their investment and on dispute resolution. Perhaps you would tell us from your point of view as a practitioner, what is it that your clients are looking for when they move into a new overseas market, perhaps like the Kingdom of Saudi Arabia?
Microphone doesn't seem to be working. Oh, perfect, it's on. Thanks, Jonathan. So I think what clients are looking for, which probably is not terribly surprising, is predictability, transparency, confidence in process, and a belief that the outcome can be enforced. And I think that's certainly a huge part of what the SCCA is successfully doing. So let me try to break down a little bit of what each of those things mean. So first of all, we talk about legal certainty and predictability, which is critical to clients who want to know that there isn't going to be a sudden legal change, a sudden change in the rules that they couldn't predict that would change the reason why they chose a forum in the first place. A transparency in terms of what the process and regulations are. As clients of mine across the globe decide whether to enter, what forum to select for an arbitration resolution, they want to really be sure that if something goes wrong, they understand and can predict the risks. It doesn't mean there aren't going to be risks, there are always risks. But it means they want to be able to assess and have a good idea of what those risks are and what the possible outcomes might be. Obviously, regulatory stability and transparency go hand in hand with that. I think efficiency and speed are something that comes up all the time with clients, which the SCCA has been quite attuned to. So clients generally, they do not want a process that might drag on for months, years, before it even actually gets to the point of an arbitrator being appointed. And in the United States, I can say we've got a lot of problems with that type of thing, where you might just be in limbo for 6, 8, 10 months before you can even get someone appointed. So I think the speed of the process and efficiency of resolution is quite important. And then obviously the ability to be flexible, for the parties to name an arbitrator that they feel comfortable with, for that arbitrator to show a real understanding and expertise in the process, and for them to feel confidence in the way that process works and the way that process will be enforced, and that they believe in the neutrality of the process, that there's nothing tilted one way or the other. Those are certainly of probably the most critical importance. And look, access to the rule of law, access to being able to enforce the judgments, confidence in that, which we're seeing here, is critically important over time, and protections against uncertainty. They don't want to go to places where they feel like they might not know what the outcome is. And the work that the SCCA has done, I think, is critical, which I think a lot of which was just outlined by the prior speaker, to address those types of concerns and to give clients and to give investors across the globe the desire to say, you know what, this is the hub we want to come to. Especially to do things like we've seen done in Singapore and other places, to make this the regional hub at minimum, let alone the global hub long term of arbitration. And I think what we've seen is a gold standard system put into place here in terms of looking at the very best modern and efficient and technological approaches to arbitration that the SCCA has looked at, which are being implemented, which I think positions it for great success.
Thanks very much, Steve. Abby, the contribution to economic growth was highlighted by the paper written by the Nobel Prize winners in relation to institutions when they won the Nobel Prize for 2024. Now, you are, of course, a board member of SCCA, a very important institution here in Saudi Arabia. But perhaps you could give us your view of the importance of institutions to the outcome and the predictability in dispute resolution from your experience.
Absolutely. Well, parties doing business need to trust that their contracts will be respected and enforced, and that disputes will be resolved in a fair and in a reliable manner. Courts, of course, play an important role. They provide a forum to fill that function. So we may ask ourselves, why do investors, why do business partners working in a cross-border setting prefer international arbitration? The main reason is that in the cross-border context, Parties seek a neutral means of resolving disputes. Neutrality not only between the parties, but also neutrality as to the law and as to the procedures that will apply. That desire for neutrality is mainly what drives parties to arbitration. So when we consider what parties seek from arbitral institutions, that's the first aspect to bear in mind. But arbitration must be more than neutral. It must be effective. And for effective dispute resolutions, parties also seek several additional features. They seek expertise. They need arbitrators with knowledge of the relevant field and of the law. They often seek confidentiality to protect sensitive information, to safeguard reputation, and sometimes to preserve a working relationship. They absolutely want to control time and costs. In this sense, dispute resolution needs to be accessible. The expression time is money is a very real factor. And while we all may be in the business of resolving disputes, for the business community at large, disputes impede business, and we must never lose sight of that. Parties look to arbitral institutions to deliver these features. Arbitral institutions earn the trust of parties when they consistently appoint neutral, impartial arbitrators with the right expertise, when they maintain arbitration rules that are transparent and that are predictable, and when they can be counted on to provide the necessary administrative support and reliable oversight. In addition to the several major international arbitration institutions that many of us are familiar with, such as the ICC, the development of regionally based arbitral institutions is serving a growing need and is playing an extraordinarily valuable role. Regional arbitral institutions, such as the Saudi Center for Commercial Arbitration, offer several advantages over the main institutions without compromising neutrality. They do so in several ways. They offer regional expertise, understanding local laws and business practices, which can be critical for an effective dispute resolution process. They offer more cost-effective solutions often, where parties benefit from, for example, a more convenient forum or venue. They are more likely to operate in the language and cultural context that may be critical to an effective dispute resolution process, to effect more significant communication and understanding. And they can develop a strong network of arbitrators and legal professionals with knowledge of the market. They can ensure compliance with regional regulatory requirements in a more effective manner. Regional centers also serve as a catalyst in the development of a culture of international arbitration in the business community. And in all these ways, regional arbitration centers provide an exceptional role in regional economic development. And of course, we must emphasize the principal reason that international arbitration works so well. Generally, that is because of the worldwide enforceability of arbitration agreements and arbitration awards. The Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also referred to as the New York Convention, is critical. There are today 172 countries that are parties to this multilateral convention, which reflects a remarkable global acceptance of international arbitration. The convention has several principal features that make it a foundational aspect of international arbitration. First, it requires courts to enforce arbitration agreements so that parties that have agreed to arbitrate will be held to that agreement. Second, it requires courts to recognize and enforce arbitral awards made in other contracting states. And it sets forth minimum requirements for an award to be enforced, typically upon the mere presentation of an official copy of the award and an arbitration agreement. Permissible grounds for refusal are defined and limited, and it requires equal treatment of foreign with domestic arbitral awards. So in the end, it is the courts that play a vital role of ensuring the effectiveness of international arbitration, and without their support and without the support of the judiciary, none of this would be possible. And there.
Thank you very much, Abby. Fei Ning,
Right.
you practice in an economy which has shown significant growth over the last 20 or 30 years. How has legal frameworks responded and supported the improvement and prosperity in China, in your view?
Thank you. As a China's practitioner, I shall share with you some insights into China's arbitration transformation and reform. And over the past 30 years, I will also highlighting the key reforms, the current statute of commercial arbitration in China, and our judicial support for enforcement, and also our present efforts in developing and improving our arbitration system. First of all, regarding the evolution of China's arbitration system. 30 years ago, China still kind of administrative model in nature for arbitration, which means all domestic disputes should submit, to the administrative body as an arbitration body, which actually party, first of all, the party cannot choose. Secondly, the award is appealable, which is not final. And also, that arbitration body is part of government agent. So that was before our arbitration law enactment, which happened in 1995. However, after 1995, arbitration law create a new and modern arbitration system, which actually the core reform brought our Chinese arbitration law in the different perspective. First of all, parties' autonomy, which means parties are free to select arbitration body, not have to go to, obey or government appointed party. We emphasize parties' autonomy. Second, arbitration institution is independent, is detached with the government agent. They are independent. And the third, one final decision, which means generally the award is final, not appealable, except some exceptions. And the third, judicial review will only be limited on the certain very limited ground. Basically, most of the cases will not be interfered by the court, even into the interpretation regarding the arbitration agreement validity issue or the enforcement issue. So the PRC judge or court will not really heavily influence or interview. So this kind of reforms provide a huge different improvement and the foundation for the growth of China's arbitration practice, which actually after 30 years practice, right now China has about more than 280 arbitration institutions, which covers wide range of commercial disputes like contract disputes, investment disputes, trading disputes, construction disputes. All kinds of commercial contracts can be submitted to the arbitration. 2023, China, the whole arbitration institution handled 600,000 cases. And last year was 750,000 cases last year. And arbitration becomes more and more popular for the business people. They are get to used to that. They are get to know to that. And many of Chinese arbitration institutions already obtained their recognition. I mean, a few arbitration institutions like CTEC, like a Beijing Arbitration Center, like a Shanghai International Arbitration Center, like a Shenzhen Arbitration Court, those are already recognized not only in China, but also globally be recognized as outstanding arbitration institutions in China. Now, regarding judicial support, a critical aspect of arbitration effectiveness is the judicial support in enforcing the award. And the Chinese court has consistently upheld Chinese arbitration agreement as well as enforcement award in line with New York Convention, which actually China joined New York Convention in the year of 1987. The key judicial principle guiding the arbitration enforcement, including, first of all, pro-enforcement stance. Generally, in the last few years, the setting aside rate less than 5%. And many of them, even within the such 5%, is largely domestic disputes. But for foreign-related disputes or foreign award enforcement in China, the setting aside rate is about 1% or 2%. Because right now, the China still implement two different separate policy. For domestic disputes, the court generally, they will not review the merits, but with some exception, something like evidence be forced or public interest. But for foreign-related disputes, the PRC court don't touch merits, governing law issues, only procedure, only public interest. So very light touch, very limited review about award review. This is quite different. And the third is for foreign award enforcement or foreign related disputes award enforcement. If the court wants to refuse or set aside, they have an internal reporting system, which means basically enforcement court is a PRC intermediate levels court. However, if that court wants to or plans to set aside, they cannot make decision. They have to report to high levels court, we call the high court. Then high court will report to the Supreme Court, so that any foreign award enforcement be set aside must be decided by Supreme Court. No any low levels court. It's highly controlled. So as a practitioner, I know in China, if I want to set aside any award outside of China, that's very, very difficult. So that's our judicial support for the arbitration. And also regarding our system, a few years ago, China's court established a special court system we call the CICC, which is the China International Commercial Court. That court is a department of the Supreme Court, which actually particularly focus on those high-profile or complex cases or the enforcement of foreign award, which is a big amount like 30 million US, or very influential cases, which actually the CICC court will directly deal with that in order to protect any local protectionism. So this is also PRC court try to provide even high levels control or high levels guideline for the low levels called how to enforce, how to support arbitration practice. So in that situation, our Chinese arbitration law has been practiced over 30 years. Now we are in the time to our first amendment of our arbitration law. According to the a few months ago, that draft has been published for invite public consultation. But from that draft, we can see some significant progress based on the draft of the amendment. First of all, which actually clarifying that Chinese arbitration institution is a non-profitable organization. That's the first time be clarified. Second, allowed foreign arbitration institution to establish and operate their arbitration practice in China. And the third, recognizing the concept of place of arbitration or seats of arbitration. And fourth, recognizing the competence principle, which means give the tribunal the self-decision regarding jurisdiction issue. Before that, everything must be decided by PRC court. And also allowed the party to choose the arbitrator, not only from the panel list, but from the outside of the panel list. Because in China, every arbitration institution has their panel, arbitrators panel. Normally, previously, you have to select arbitrator from that panel. Now, you are free to choose either within the panel or outside of the panel. And many of the arbitration institutions, their panel, a lot of foreign international practitioners on that panel. For example, CTAC or BAC or SIAC, they have 100 people, from outside of China. Hong Kong barrister, Singapore lawyer, American lawyer, or arbitrator from London, many of them. So also, particularly for the ad hoc arbitration, previously China, no ad hoc at all. But now it's open door for the ad hoc. Not all, but it's in a certain economic special zone is allowable for ad hoc practice in China. So this kind of improvement and changes may give Chinese arbitration practice even more international, more modern. So, of course, we know we had made a big progress in the last 30 years. However, I have to say, well, we still a long way to go. For example, so many arbitration institutions, they are not well balanced. Some, I think, low percentage of arbitration institutions are more approach to international standard. Many of them still behind. And secondly, we still lack of very efficient or professionalism for either for counsel or for arbitrator. We don't have enough because we have so much big case loads, but we still lack of a certain, professional people. And also, for the low levels called some area, not developed area, their understanding about the arbitration practice is a little bit behind. So this is we still have something we have a lot of things we need to improve.
That's probably a good place to leave us.
Sorry, I just finished. But I believe we are on the right track. Yeah, we're already on the right track. And we will and we sure have a great future. Yeah. Thank you about that.
Well, I think it's very interesting because you have come from what was an administrative process to one which is much more neutral. It's taken its time, but it's certainly well established now. And I think the sheer number of arbitrations that's going on is reflective of the sheer size of China and its huge population, of course. Right. So I think that's very interesting. So I now turn to another country. And Joke, you and I have discussed this question before because it's a question I always ask about Nigeria because I think people don't quite appreciate. Tell us what the population of Nigeria is.
All right. You know, Nigeria is usually called the giant of Africa, and that's also partly because of our population. So current population is over 230 million Nigerians. 70% of that population is under the age of 30. So it's a really young population as well in Nigeria.
Quite remarkable. And one of the issues is the different tribes and languages that are in the nation of Nigeria itself.
So there are over 300 tribes,
Yes.
which also spells into over 300 languages.
300 languages. So there's quite a lot of differences just within the one country, which,
Exactly.
you know, have to be dealt with when it comes to dispute resolution. But perhaps you could tell us how dispute resolution has developed in Nigeria, particularly in the context of ADR.
Thank you for the question. You know, Nigeria was colonized by Britain and became independent in 1960. So our first arbitration law was during the colonial era, and that was the Arbitration Ordinance of 1914. I would have asked you to guess how long we had that law for. Well, we had that law for 74 years until 1988, when for the first time there was, you know, local law in Nigeria on arbitration, the Arbitration and Conciliation Decree, and that was because it was made during the colonial era. It later became popularly known as the Arbitration and Conciliation Act. Now, it was modeled after the ancestral model law of 1985, and Nigeria was in fact the first African country to adopt the model law. But we adopted it in what I would like to describe a unique way. So out of about 51 provisions on arbitration in that law, 22 of them were verbatim adaptations of UNCITRAL 1985. 16 were adaptations of UNCITRAL 1985 with some variations here and there. And sometimes we'll drop a subsection, modify a section, and 10 of them were retentions of the ordinance or had nothing to do with either the ordinance or the UNCITRAL. By and large, we say it worked well because it recognized principles like competence. It recognized party autonomy, limited interference by the courts, but of course it came with its challenges, as you would expect. So I'll share a few of the challenges with you. Now, because we had a framework that we had drawn from the model law, we had modified certain provisions, we had also retained some from the ordinance. We ended up first with a situation where we had two provisions on stay of proceedings. Now, stay of proceedings becomes relevant where one of the parties to arbitration institutes or commences a court action, you know, in violation of the arbitration agreement. And one of the provisions in the law was that the courts had discretion to stay the court proceedings in that circumstance. The second provision was that the courts shall, in other words, had no discretion to stay proceedings in that instance. And they also had different provisions as to the timeline. In other words, how soon after the institution of the action must you bring the application for stay of proceedings. And what that presented was something that Steve had mentioned when he started his presentation, which is that there was no certainty because we had two different directions as to what could happen where there was court proceedings in violation of an arbitration agreement. You weren't certain whether the court was going to stay the proceedings because it considered it mandatory, or whether it was going to decide that it had discretion as to whether to stay it or not. I think the second challenge we had was that we had a default provision that if parties did not agree on the number of arbitrators, then the default number of arbitrators will be 3. Now imagine that with a 3-man panel, you have a more expensive arbitration proceedings. And so that was unattractive and a disincentive for SMEs and for smaller claims in arbitration. Aside from that, also on the judiciary side, we had a very interesting decision where a court decided that in determining whether an action was statute barred, and the statute bar argument comes in when a party says you're already out of time to file your action in court. When a party says that there's a limitation period for filing your action in court and that you're beyond the limitation period. So we had an interesting court decision that the time continues to run during arbitration proceedings. And the potential impact of that was that you could go through the entire process of arbitration, come up with a favorable award that you were then unable to enforce, because by the time of the award, you would have been statute barred, especially for claims in contract which had a 6-year limitation period under Nigerian law. I'll mention a last one which had to do with the grounds for setting aside an award. And one of the grounds was the ground of misconduct of an arbitrator. And it wasn't so much of that ground, but the way it was interpreted. So it was interpreted in a very liberal way to include what was described as error of law on the face of the award. So we had several cases where unsuccessful parties in arbitration would seek to challenge an award on the basis that there was an error of law on the face of the award. And don't ask me what that means. So there were several cases on that, even though there was nothing in the law itself that provided for error of law on the face of the award. So we're coming from that journey when in 2003, there was a new Arbitration Act, the Arbitration and Mediation Act, which was very well embraced because it addressed all these issues that I already described. First, it provided that the default number of arbitrators will now be 1 and not 3. It also was very clear about the stay of proceedings, eliminating the second provision on discretion and imposing a mandatory stay. It also recognized, other provisions that were missing in the previous law, things around consolidation of arbitration proceedings, multi-party proceedings, joinder in the course of arbitration proceedings, and streamlined the grounds for challenging an arbitration award. I think one of the interesting provisions was also the provision on the arbitral review panel, which is an opt-in provision that allows parties to, submit an award to a review panel, and where the panel affirms the award, it limits the grounds for which they may challenge the award subsequently.
So this is a separate review panel
Exactly.
of the award outside the court system.
It's outside the court system, and it's a different review panel from the initial arbitral tribunal. It's constituted the same way you constitute your initial panel, but of course there will be different parties or different panel considering the award. And once that panel affirms the award, then you can only challenge the award in court on 2 grounds: arbitrability or public policy, and nothing more. So those are some of the innovations under the new Act. But I would say that there are 3 major lessons, that we learned, and several more actually in the course of that journey. I mean, the first is there's nothing wrong with adopting a template, and there's nothing wrong, of course, with modifying a template to suit local circumstances. But then there needs to be serious considerations when you're doing that, so that you don't end up in a situation like we did initially, where we had 2 conflicting provisions on the same subject. I think the second is that it's critical to have the buy-in and the understanding of the supporting institutions, and that would include the courts. And you know, sometimes people have asked, what's better? Is it better to have a good law and bad interpretation or implementation? Or is it better if you have a bad law, but then you have good interpretation and implementation? I really don't want to be in a position to choose. I think it's important you have both a good law and then good implementation and interpretation. But having the support of the institutions, I think it's critical. And that brings me to, I think, what was discussed earlier today on seeing it as an ecosystem. So it's not just the law in isolation, it's that the law exists in an ecosystem. And there must be that buy-in into the policy itself, you know, and into the objective that's, you know, is the focus to be achieved. And I think lastly is the fact that business is evolving, commerce is evolving, competition is growing, and so you can't afford to review your laws once in 70 years. I guess it's just important to ensure that the law is also moving, you know, in consonance or alongside, you know, development and the complexity of commercial transactions. I'll leave it at that because of time. Thank you.
Yeah. Thanks very much, Aluko. And of course, the point you make about moving with the times in English, and in England, I think yesterday the arbitration bill became the Arbitration Act. After, you know, it was 25 years before it was reviewed. So it takes time for these, and I must say, the work of the Law Commission and those behind it, there was a lot of effort put in to change the law in the UK as well, or in England, should I say. So yes, we're ad idem on that point. We don't need to take two. I hope it's not going to be 25 years before we start looking at it again, particularly in light of the changes in technology.
Exactly.
But let me move now to Martina. Martina, you represent one of the most prominent institutions in terms of arbitration for foreign investors, ICSID. And I think it would be very helpful if you were to outline what the role of ICSID is for the audience. So the floor is open to you, if I may.
Thank you, Jonathan, and thank you to the SCCA. It's an absolute pleasure to be here. My first time in Riyadh, and it's an honor to be speaking on this panel. Now, I am going to talk about a slightly different ecosystem, the ecosystem in investor-state dispute settlement. And ICSID is at the front of that system. ICSID is the International Center for the Settlement of Investment Disputes. And as some of you may know, we are part of the World Bank Group. And we were created by an international convention, the ICSID Convention. And this year is a particularly exciting year for ICSID because we're celebrating 60 years since the adoption of the ICSID Convention. It was adopted on March 18, 1965. So we'll have a little celebration about that. Now, the purpose of the convention was to create facilities for the resolution of these investor-state disputes, and with the ultimate goal of promoting foreign investment. So there was a thought behind it, and that is to promote private sector investment flows into countries who wanted to be part of this system. And so you always have an investor on one side and a state or a state agency on the other side, and it has to concern an investment. Now, the idea arose in part because in the 1950s and 60s, the president of the World Bank was sometimes called on to help assist with resolving investment disputes. And one notable example that concerns this region was the nationalization of the Suez Canal in the 50s. After the Suez crisis, there was a dispute about the amount of compensation due to the expropriation of the canal that was due to the shareholders, the British and French shareholders. And so Egypt and the United Kingdom came to the World Bank and asked for assistance. And the president back then, Eugene Black, hosted them at the World Bank offices, and there was a settlement reached in 1958. And so the assistance of the World Bank helped to peacefully resolve the dispute. And as a result, the World Bank and states who were shareholders in the World Bank started to think about how can we use this dispute resolution for other purposes, not only for peaceful resolution, but also for economic development, and in particular for promotion of investment, for the very reasons that Stephen mentioned: predictability, the rule of law, and security that if I invest abroad, my investment is protected. Now, there were some issues that needed to be addressed. In particular, when you have a dispute with a sovereign, there are issues of immunity of jurisdiction of that state. And the ICSID Convention addresses that issue because it allows direct access between the state and the investor. That was a major breakthrough back then. It may not be so now, but it was unique back then. And it's also unique because it has its own self-contained legal framework, and you don't see that in any other arbitration circumstances. So you have provisions for how to file the request for arbitration or conciliation, and it goes through the whole process, including post-award remedies and enforcement. So you don't have a seat of arbitration in the legal sense. You don't have a lex arbitri because you don't resort to national laws in the process. And you don't go to domestic courts to set aside the award. The only thing you do go to local courts to enforce the award. But that's it. The enforcement mechanism is right there. So instead, you have certain limited post-award remedies, notably annulment. So you do have some remedies against an award, but it's within the framework of the convention. And this is very attractive to those who want a predictable and stable legal framework, because you don't have to second guess, well, if the seat of arbitration is this, that will apply. And often in these disputes, you don't know what the seat of arbitration is when you start the dispute. And that is something that in particular investors think about when they select where to go. And it's also a system that carefully considers the interests of both states and investors. And that is key because you often have or almost always have the claimant as the investor is the claimant, and the respondent is usually the state. And so you need rules that balance out the interest of the two for building trust and confidence in the system. And we have always sought to maintain that. When we updated our rules in 2022, and that was a major overhaul, we took into account all stakeholder comments, including states. And so we implemented those changes, and they have been very well received and working very well so far. Now, finally, I want to mention one important point about ICSID, and this is sometimes a misconception. States that become member states of the ICSID Convention, and we have 158 of them now, they send a very strong signal to foreign investors that they're open to receive their investments and their foreign investments, and that they are ready to arbitrate or conciliate or mediate with them at exit. That they do. But that in itself is not enough to start a dispute. You need consent to arbitration and to conciliation and to mediation. And you do that by either concluding an investment contract with an exit clause or by reference to a treaty, investment treaty. And many or most of these investment treaties do refer to exit as one of the options. And in fact, almost 80% of our cases are nowadays based on these investment treaties. And we've become sort of synonymous with treaty arbitration. And that is something that we would like to change. Because in the beginning, we were all about investment contracts. Our 18 first cases were based on contracts, including one case initiated by a Saudi Arabian investor, Gaith Pharaon versus Tunisia, which was a hotel development, and which eventually settled. Now, given that our rules are specifically designed for these disputes between investors and states, there is merit in considering exit also for investment contracts, of course, when the jurisdictional requirements are fulfilled. And we will be raising awareness about that, this option, with new model clauses and a background paper on our contract cases. And so we hope to be promoting our newly expedited arbitration rules also with this effort, which was specifically meant for contracts.
Thank you. I think expedited arbitration is a sort of conference in its own right, because they're becoming more and more popular. As Abby said, time is money, so expedition is important in the context of arbitration. But there is one point I'd just like to ask you about. Abby has already referred to the New York Convention as a way of enforcing commercial arbitration awards. I think there's a distinction to be made for enforcement of awards under the ICSID regime. I wonder if you could just identify that distinction for us, please, Martina.
Right, there is an important difference, and this is often why, in particular, investors want to choose the ICSID Convention regime, because in the ICSID Convention, states commit to recognize and enforce award as though they were final judgments of their own courts. So domestic courts must enforce an award as though it is an award, a judgment of their own courts. And unlike the New York Convention, the ICSID Convention does not provide any grounds for refusal of enforcement. So if you have an ICSID award, a certified ICSID award, you can go to any of the 158 member state courts and have it enforced in those courts. Of course, immunity from execution still applies, but that is the same regime as under the New York Convention. And that is even mentioned in the ICSID Convention, that you do have immunity from execution. Now, you may be interested to hear that last year we published a paper about surveying sort of the compliance and enforcement with ICSID awards. It's published on our website, and it does confirm that this regime works well. We looked at both compliance rates, and we saw a compliance and enforcement rate of approximately 70% of damages awards against states. So that's a fair number. And we also looked at how states have gone about in their enforcement efforts. And we saw that an overwhelming majority did enforce, and they do not review the merits or jurisdiction of the award and limit sovereign immunity defenses to the execution stage.
Although I do think that there are more unpaid awards than there were when I started first dealing with these sorts of cases many years ago. I'm afraid there are plenty of unpaid awards. But what I'd just like to raise now is There has been disquiet about ISDS, and I just wondered what the mood is in Washington about this generally. Now, Abby, this is an area where you practice. What's your thinking about this? Is there overwhelming enthusiasm for ISDS, or is it the other way round?
Well, I think what needs to be emphasized is that investor-state arbitration really needs to be seen as a last resort. It is, it tends to be more complex than a typical commercial case. They are proceedings that should not be undertaken lightly. And I think there's an increased awareness of that, as there have been so many more now completed arbitrations. I think parties can look and see the track record and understand that it's complex and, again, really a last resort, an important last resort, but nevertheless, a last resort.
So an interim way of dealing with them is perhaps by mediation. And Martina, I think there are rules established by ICSID for mediation. How has this grown in popularity, or is it in its infancy?
So we have, does it work?
Does it work?
Oh, testing, yeah, no. So we did adopt new mediation rules in 2022 because we saw a great interest, in particular by states, in this service. And we've seen, and especially in this region, great numbers in cases that did not lead to awards. So about 50% in this region discontinued, either because they settled or for some other reason, before the tribunal ruled on the case. And so that gives hope that there is room for settlement, and I do think that this region in particular can lead that, to enhance amicable solutions through the use of mediation. There's great potential in that, and we'll be working with our partners in this region to do that, to promote mediation and other forms of early settlement of disputes.
I think this is commendable. And we could have a whole session here this afternoon on the benefits of mediation. I know that there have been discussions throughout the week on mediation, but time is against us. And so with those last comments, I would like to thank my panel and ask the audience to show their appreciation in the usual fashion. Thank you very much indeed.